If you are currently holding a 2-year conditional green card, or if someone close to you is approaching that 2-year mark, then the information you are about to receive over the next several minutes could genuinely determine whether you continue building your life in the United States or find yourself facing removal proceedings. I am asking you to stay with me through every part of this video because I am going to take you through the 3 most frequently occurring and most damaging errors that conditional green card holders make when they submit their I-751 petition. These are mistakes that immigration attorneys working across the country and guidance published directly by USCIS confirm are completely and entirely avoidable. And I am not simply going to tell you what those mistakes are. I am going to explain precisely what you can do, starting right now today, to safeguard your immigration status and give your petition the most solid and defensible foundation it can possibly have. I am glad you are here, and I give you my word that every minute you invest in watching this will be worthwhile. Let us begin with the foundational information, because if you are new to this process or if you are helping someone you care about work through it, you need a clear understanding of what we are actually discussing before we examine the errors people make. When a foreign national obtains a green card through marriage to a United States citizen or a lawful permanent resident, and that marriage had been in existence for fewer than 2 years at the point when the green card was approved, USCIS issues what is formally known as a conditional green card. This document is visually very similar in appearance to a standard green card, but it carries one fundamental and critical distinction. It is only valid for a period of 2 years. The condition that is attached to it functions essentially as a supervised waiting period, during which the federal government seeks to verify that the marriage in question is authentic, genuine in nature, and not simply an arrangement entered into for the purpose of gaining immigration benefits. When that 2-year period reaches its conclusion, the conditional resident is required to file Form Y-751, which is formally titled the Petition to Remove Conditions on Residence, in order to demonstrate that the marriage was entered into with genuine intent and to formally request the full standard 10-year permanent green card. That is the specific process we are focused on throughout this entire discussion. Now, as of April 2026, USCIS has meaningfully increased the level of scrutiny it applies to these filings. Based on guidance reflected in USCIS policy and the observations of immigration practitioners working in this field, the agency has reduced the number of interview waivers it is willing to grant, and is currently requiring a larger proportion of I-751 applicants to attend in-person interviews compared to what was required in previous years. Processing timelines have also extended considerably beyond what many applicants expect. As of April 2026, USCIS is taking approximately 28 to 32 months to complete processing on 80% of I-751 petitions, which translates to most applicants waiting well in excess of 2 full years before receiving a final determination. The receipt notice you receive after submitting your petition does provide a 48-month automatic extension of your lawful permanent resident status, meaning your ability to live, work, and travel remains protected throughout that extended waiting period. But none of those protections matter in the least if your petition gets denied before it ever reaches that stage. And that is the precise reason we are having this conversation today. So let us examine the first mistake, and this particular one may catch you off guard because it sounds almost deceptively straightforward. But immigration attorneys will tell you repeatedly and consistently that it stands as one of the most frequently cited contributing factors in denials and in requests for evidence, which is essentially a formal notification from USCIS that the materials in your file are not considered sufficiently strong to support approval. That first mistake is filing either too early or too late, or submitting your petition on the wrong version of the required form. The regulations surrounding timing are highly specific and they carry no flexibility whatsoever. USCIS requires that if you are filing jointly with your spouse, meaning both individuals are signing and submitting the petition together as a couple, Form I-751 must be filed during the 90-day period that falls immediately before your conditional green card reaches its expiration date. That is a strict and rigid 90-day window, not 91 days before expiration, not 95 days, not 3 months and 1 week ahead of the deadline. Exactly 90 days. If you submit your petition even a single day before that filing window officially opens, USCIS will reject the petition entirely and return it to you. And if you allow your card to expire before submitting your petition, you could be placed directly into removal proceedings and face immigration consequences of a very serious nature. Consider for a moment how easily important administrative tasks get deprioritized when life is demanding your attention from every direction. You are managing your career, raising your children, running your household, and that card expiration date has been sitting somewhere on your refrigerator or your desk for 2 solid years without creating any particular sense of urgency. Then one day it suddenly becomes apparent that the filing window is only a few weeks away, and the scramble to pull everything together begins in earnest. That scramble is precisely the environment in which costly mistakes occur. The form gets completed in a rush, supporting documents are pulled together incompletely, and critical signatures get overlooked or missed entirely. So here's the action I want you to take right now before you watch another minute of this video. Locate your conditional green card. Find the expiration date printed on the front of the card, then count backward exactly 90 days from that expiration date. Mark that calculated date on your calendar and label it clearly as the first day on which you are permitted to file. Then mark the expiration date itself as your absolute final deadline. That stretch of time between those two dates is your window, and everything needs to be fully prepared and ready before that first date arrives. There is an additional element to this timing issue that a surprising number of people fail to account for. USCIS updates and revises its forms on a periodic basis, and submitting an outdated version of Form I-751 can result in your petition being automatically rejected without any substantive review of its contents. Before you download the form, navigate directly to the official USCIS website at uscis.gov and verify that you are obtaining the most current edition that is available. The edition date is printed along the bottom of the form itself. Do not use a version you downloaded and saved to your computer 2 years ago. Do not use a form you obtained from any third-party website or service. Always go directly to uscis.gov to obtain the most current and valid version. And if you have any uncertainty about whether the version you have is correct, a qualified immigration attorney can confirm this for you in a very brief consultation. This single verification step takes fewer than 5 minutes to complete and has the potential to save you months of frustrating delay in your case. Now let us move forward to the second mistake, and this is the area where a significant number of petitions completely fall apart in the review process. The second most frequently occurring reason that I-751 petitions are denied is the submission of insufficient evidence establishing a bona fide marriage. The Latin term bona fide translates simply to genuine or in good faith in the context of immigration law. What USCIS is seeking to confirm is that your marriage constitutes a real and authentic union between two people and not a relationship structured primarily or exclusively for the purpose of obtaining immigration benefits. And here's the reality you need to absorb fully. Asserting that your marriage is genuine is not sufficient on its own. You are required to demonstrate it. You are required to substantiate it with concrete and credible documentation. And the standard of what qualifies as adequate proof has risen significantly under the policies currently in effect at USCIS. So what does a genuinely strong evidence package actually look like in practice? According to USCIS guidance, a thoroughly prepared I-751 petition should include documentation that collectively tells the story of a shared life being built together. Joint tax returns, reflecting that you and your spouse filed together as a married couple. Joint bank account statements demonstrating regular and ongoing shared financial activity over a sustained period. A shared residential lease or mortgage document confirming that you have maintained the same address together. Utility billing statements that carry both of your names. Health insurance policies or automobile insurance documents that list both spouses as covered individuals. Records documenting any children you have had together as a couple where applicable. Photographs drawn from across the full span of your marriage, not simply from your wedding ceremony and reception, but from holidays spent together, family gatherings and events, vacations, and the everyday moments that make up an ordinary shared life. Affidavit statements from individuals who know you both as a couple, including friends, relatives, colleagues, and others who can describe in their own words and with personal specificity the nature of your relationship and what they have personally witnessed and observed over time. Now, I want to make something absolutely clear at this point in our discussion. USCIS officers who review these petitions are experienced professionals. They examine hundreds of these filings in the course of their work. They are fully capable of distinguishing between a documentation package that was hastily assembled with a minimal collection of materials and one that genuinely and organically reflects two people constructing a life together over time. Evidence packages that are thin and sparse raise immediate red flags for reviewers. And in 2026, with heightened scrutiny being applied across the board and in-person interviews being required far more frequently than in prior years, those red flags translate into real and serious consequences for applicants. If USCIS determines that your submitted evidence is insufficient to support a favorable determination, they have the option of issuing a request for evidence, which grants you a limited and defined period of time in which to gather and submit additional supporting materials. However, if the overall picture presented by your petition is weak enough in the judgment of the reviewing officer, they may deny the petition outright and issue a notice to appear before an immigration court. Here is my specific and practical recommendation for addressing this area effectively. Do not allow yourself to wait until you are already inside the 90-day filing window before you begin the process of gathering your documentation. Begin that process now. Create a dedicated folder, whether physical or digital, and begin systematically collecting joint financial statements, insurance documentation, lease or mortgage agreements, and photographs. Go through your tax filing history and make certain that you have copies of every joint return you have filed as a married couple. Identify the individuals in your life who would be capable of writing a strong, personal, and detailed affidavit statement about your relationship, and reach out to those people now before the pressure of an approaching deadline enters the picture. And if your evidence base happens to be limited for any legitimate reason, perhaps you and your spouse maintain separate financial accounts for sound personal reasons, or perhaps you spent a period of time living apart temporarily due to professional obligations or family circumstances, please consult with a qualified immigration attorney who can assist you in framing your particular circumstances accurately and constructing the most compelling possible case given the specific details of your situation. Let us now address the third and final mistake. This one is perhaps the most nuanced of the three we are covering today, but it carries critical importance in 2026 given the enforcement environment that currently exists around these filings. The third mistake is entering a USCIS interview without adequate preparation, or in the worst cases, attending one with no real understanding of what the interview process actually entails and what it is designed to evaluate. As we discussed earlier in this video, USCIS has substantially pulled back from its previous practice of routinely waiving the requirement for in-person interviews in I-751 cases. Under the policies currently in effect, as of 2026, a considerably larger share of applicants are receiving interview notices than was the case in previous years, and the officers conducting those interviews are posing more detailed and pointed questions than a significant number of applicants anticipate encountering. What does this mean in concrete and practical terms for you as an applicant? It means that you and your petitioning spouse need to be genuinely capable of speaking about the life you share together with a level of specificity, ease, and mutual consistency that reflects authentic familiarity. Officers conducting these interviews may ask questions such as, what time does your spouse typically wake up in the morning? Who handles the grocery shopping in your household? What is your spouse's mother's full name? Describe a holiday occasion you celebrated together in recent memory. Where did the two of you spend your most recent anniversary? These are not designed as trick questions intended to trap or confuse you. They are the kinds of questions that any two individuals who are genuinely sharing their lives together would be able to answer comfortably and without any hesitation. But they can be genuinely startling and disorienting if you walk into that interview room without having given them any prior thought or preparation. There is also a specific type of interview procedure used in immigration cases that is worth understanding clearly. It is commonly referred to as a Stokes interview, a name derived from a court case that established and formalized the procedure. In a Stokes interview, USCIS officers separate the couple being evaluated and conduct independent questioning of each spouse in separate rooms, after which they compare the answers provided by each individual and look for inconsistencies or contradictions between them. If the answers given by the two spouses do not align with sufficient consistency, officers may draw the conclusion that the marriage is not genuine. I want to be straightforward with you about this. Not every I-751 interview escalates to the level of a Stokes interview. But when the submitted evidence is thin, when discrepancies are identified in the documents that were filed, or when the reviewing officer develops concerns during the initial questioning, a Stokes interview becomes a very real possibility that you need to be prepared to face. The most effective way to reduce the likelihood of encountering this level of scrutiny is to arrive at your interview with a robust and comprehensive documentation package and a genuine, well-considered, and consistent account of your shared life together. So here's what I recommend you do in the weeks leading up to your scheduled interview. Set aside dedicated time to sit down with your spouse and have a genuine conversation about your life together. Walk through the full timeline of your relationship from the beginning. Recall when you first met each other, how your romantic relationship developed, when you became engaged, how your living situation evolved over time, the financial decisions you have made together as a couple, and the family events and occasions you have shared and attended. Work through basic biographical questions about each other in a natural and conversational manner that reflects genuine personal familiarity rather than rehearsed or scripted answers. Assemble your complete evidence package and bring it with you to the interview. Bring both original documents and copies. Dress in a way that communicates respect for the process. Arrive at the interview location ahead of your scheduled appointment time and engage with the officer in a manner that is courteous and professional throughout. And hold on to this perspective as you prepare. The purpose of the interview is not to catch you making a mistake or to find a reason to deny your petition. It is to confirm the authenticity of what your submitted documentation has already demonstrated. If your evidence package is strong and your relationship is genuinely what you have represented it to be, the interview simply becomes an opportunity for you to personally affirm on the record what you have already established through your submitted materials. There is one additional matter I want to address before we bring this discussion to a close, and it pertains to a situation that many people encounter but are uncertain how to approach or resolve. What do you do if you are no longer in your marriage by the time your 2-year conditional period comes to an end? What happens if the marriage ended in divorce? If your spouse passed away? Or if your spouse is refusing to participate in a joint petition filing? These are deeply difficult and painful circumstances, and they can feel like they leave you with no viable path forward, but it is important to understand that legal options do exist. USCIS permits conditional residents to file Form I-751 on their own as an individual without the participation of their spouse by formally requesting what is known as a waiver of the joint filing requirement. These waivers are available in specific qualifying circumstances, including cases involving divorce or annulment of the marriage, the death of the petitioning spouse, battery or extreme cruelty inflicted during the course of the marriage, or a situation in which removal from the United States would result in extreme hardship for the applicant. It is important to understand that petitions filed on a waiver basis are substantially more complex in their preparation and requirements than standard jointly filed petitions, and they typically require a considerably more detailed and extensive evidence package to support the request. They also frequently take longer to process through the system. If you find yourself in any of these circumstances, please do not attempt to navigate the situation on your own without professional guidance. Reach out to and consult with a qualified immigration attorney as promptly as possible so that you can begin building the strongest possible case with the time available to you. And that brings me naturally to a point I want to communicate to you clearly and with complete sincerity. Everything that has been shared with you throughout this video is educational and informational in its nature and purpose. It reflects publicly available guidance from USCIS and the current working understanding of immigration practitioners actively engaged in this field of practice as of April 2026. But immigration law does not remain static or unchanged over time. Policies undergo revision. Processing timelines shift. USCIS updates its official guidance and procedural requirements. What holds true at the time of this recording may have been modified or adjusted by the time you are preparing to file your petition. This reality is not a reason to feel frightened or overwhelmed. It is a reason to remain consistently informed, to rely on authoritative and official sources of information, and to engage the services of qualified professionals when the complexity of your specific situation calls for that level of support. Please do not make consequential decisions about your immigration status based exclusively on any single video, article, or website resource, including this one. Visit USCIS.gov directly and review the complete official instructions for Form I-751. And if your situation involves any degree of complexity or unusual circumstances, engage with a licensed and experienced immigration attorney. The stakes involved are far too significant and the nuances far too consequential to leave anything to chance or uncertainty. Before we conclude, allow me to provide you with a clear and concise summary of the 3 mistakes we have covered so that you carry them with you in a well-organized way. The first mistake is missing the 90-day filing window or submitting an outdated form version. Know your card expiration date with precision. Calculate your filing window accurately and always download the current version of the form directly from USCIS.gov without exception. The second mistake is submitting an evidence package that is insufficient to establish a bona fide marriage. Build a thorough and multi-category collection of supporting documentation that tells the authentic story of your shared life together, and begin gathering those materials now rather than waiting until time pressure forces you to rush. The third mistake is walking into a USCIS interview without having done the necessary preparation. Know your own story deeply and in detail. Know the specific facts about your life together as a couple. Prepare thoughtfully and naturally with your spouse in advance of the interview, and bring your complete documentation package with you on the day. These 3 mistakes collectively account for a substantial proportion of I-751 petition denials, and every single one of them is entirely preventable when you have the right preparation and the right information working in your favor. If this video delivered value to you, please take a moment to give it a like before you close out. That small and simple action makes a genuine and meaningful difference in helping this information reach other people who are in need of it right now. If you know someone who is approaching the 2-year mark on a conditional green card, whether that is a family member, a close friend, a neighbor, or a colleague, please share this video with them without delay. They may be completely unaware of how close their deadline actually is, and the information contained in this video could genuinely alter the course of their life in this country in a significant way. Please consider subscribing if you have not already taken that step. New content is published consistently each week, bringing you accurate, current, and professionally reviewed immigration information. Not alarm tactics, not speculation or guesswork, but substantive guidance that you can genuinely rely on when making important decisions. Activate the notification bell so that you never miss an update, because in the context of immigration matters, timing is not merely important, it is everything. A resource list has been assembled and placed in the video description section below, containing direct links to the official USCIS page dedicated to Form I-751, the current USCIS fee schedule, and the official USCIS case status tracking tool, where you can monitor the progress of your petition after it has been submitted. Every resource you need to take your next step forward is available there for you. The mission behind everything we do here is straightforward and unwavering: to make certain that you have access to the information necessary to protect your immigration status, to move through this process with genuine confidence, and to continue building the life you came to this country to build. You are not facing this journey alone. We are committed to being here with you at every stage along the way. Please take care of yourselves and take care of one another.